Just a couple of comments, and then I want to turn the floor over to Judge Shepherd. There was a question a couple of weeks ago, which I forgot to respond to, and somebody reminded me last week, on the laptops. And yes, indeed, as I thought, and as I wanted to confirm, if you're doing ExamSoft, you take your laptop in there in the morning, and then you leave it, because there's really no place else to take it. But it is secure. Nobody's going to walk out of the room with your laptop. So that's number one. Number two, you're about a month into your studies, those of you who are into your studies. I know, I'm looking at those faces. I feel your pain, been there, done that, and too many times now with all of the classes we've been studying. You guys are at the rough point right now, honestly, because the newness of the studying has worn off. And the enormity of the task is probably weighing very heavily on your head and your shoulders right now. But have faith. You too will survive. And if you're feeling overwhelmed, you can always use me as a resource. You can always use Amar as a resource. If you want to just blow off some steam, or freak out a little bit, then feel free. And I want to also say, you do have to crash and burn. I don't quite understand the psychology of it, but it has to happen. It happens to everybody, and you just want to jump out the window at a certain point. You might be there now. If you're not, you will be. It's a normal part of the process. So don't jump out the window. Just think about it. And think about it. Don't even think about it. But I promise you, if you work through it, you hit the rock bottom, and then start to ramp up in February. That's exactly what you should be doing. You should be starting to pick up the pace again and getting into your studies. So while I'm not telling you to just walk away and not do anything for a week, understand that your brain and your body are going to fight it at a certain point. Again, talk to us. We've been there. We've been through it with a lot of students. So, without further ado, two things. I'll walk around. I'll get your tickets for those of you who have tickets. Judge Shepherd will make one drawing during class, and then he will make another drawing at the barbecue afterwards. So you have two chances today. I think Judge Shepherd needs no introduction to you, but in case there's anybody in this room who doesn't know who Judge Shepherd is, he is the Chief Judge of the 3rd DCA, and we are extremely fortunate to have him not only as a lecturer for you today, because he's an expert on Florida con law, but also as a member of our faculty. So I'm going to turn the floor over to you, Judge Shepherd, and take it away.
Thank you, Dean Singer. I feel extremely fortunate to be able to be here today. I feel your pain also. It was 40 some odd years ago, about now, and it was a summer session that I took the exam, and I was scared to death. Okay, so don't worry about it. Just do it, and you will. As Dean Singer says, you go through all of this, and when you're there several days before, it'll all be in your head, and you go out there and repeat it. Today, our task is to have a fairly detailed survey of Florida constitutional law. You have before you several sets of items. Let me explain. The first is a copy of the overheads. I will be following through the overheads, and you may take notes on those if you so desire. Another thing that you have is something called Extraordinary Writs by Judge Stephen Northcutt. You get this in the judges school, actually, and it nicely summarizes about all you need to know on extraordinary writs. And you don't need to know everything in here. I've highlighted what we need to know. In addition to that, you have an article, two articles actually. You have an article and a second piece pertaining to homestead. The homestead piece is written by the guru of homestead in this state, and it is a pretty good summary of homestead. We will cover homestead today. The second piece is the bankruptcy law amendment of 5, 6, 7 years ago that, that restricts the ability to claim homestead protection if you file bankruptcy within 40 months of the time of the time you of the time that the property becomes homestead property. The next two, number one, is something by another judge, James R. Wolfe, Municipalities in the Florida Constitution. I'm not going to recommend very many cases or handouts today, perhaps 2, 3 cases if you want to read them. This document very nicely summarizes local government law and Article 7 Finance and Tax, which I consider to be the most difficult article of the Florida Constitution. The last piece and the least important, you've got a copy of the Constitution, of course, we need that. The last piece is something that I will not cover, Article 11, amending the Florida Constitution. It has never been tested, to my knowledge. However, it may be tested. At some point, it would be pretty easy to draw a test question based upon amending the Florida Constitution. And there's a lot of it that is sought presently, so I give you what I hand out in my class on the subject. And if you read Article 11, the amending process, and have this next to you, I think it'll be a lot easier for you. With that, here's what we're going to do. We are going to review every significant article of the Florida Constitution and every section therein that I believe you need to know, at least as much as I can cover today, for the bar exam. The way this 3-hour course has been designed is not just based upon my course or whatever else I've done, but I have read about 20 years worth of questions. And so I've condensed what you're going to see here from those questions and put the most important things at the top. And I feel very confident it'll be of some benefit to you. So let us begin. We will look at the highlighted articles there and a few sections within those that are not highlighted. But we will look at Article 1, the Declaration of Rights. We will look at one section of Article 2, the Separation of Powers Doctrine. We will look at the two most important pieces of Article 3, the legislative article. We will, as we go through the legislative article, weave in what you need to know out of the executive article. That's why it's not highlighted. We will spend some time, quite a bit of time, on the judicial branch because questions on the Florida bar are oftentimes crafted around a legal question, an appellate question. Doesn't have to be, but oftentimes that's the case. We'll look at finance and tax, which I consider to be the most difficult article. Local government is important because it sets the stage for finance and tax. And then we will look at Article 10, Section 4, Homestead. Let us begin. We begin with the doctrine of separation of powers. Article 2. I will not go through these in order. I'm going to go through them in a way that actually makes sense to study them. And I will be hitting some basic ones, a couple of basic ones first. Article 2, Section 3, the doctrine of separation of powers. The doctrine of separation of powers in Florida is in the Constitution. It is written in the Florida Constitution. It is not written in the United States Constitution. There it is. Article 2, Section 3, no person belonging to one branch shall exercise any powers appertaining to either of the other branches unless expressly provided herein. The thing to remember in the application of that doctrine, which is all you need to know, of course, for our purposes, there are two basic principles behind the doctrine. Number one, that no branch may encroach upon the powers of another, and number two, no branch may delegate its constitutionally assigned power to another branch. There is a single case you can read if you wish, and you'll know everything about the application of Article 2, Section 3, Article 2, Section 3, the separation of powers doctrine. That is Bush versus Schiavo, one of the Bush versus Schiavo cases. It's an interesting read. 885 Southern 2nd 78. It's only about 8-10 pages long, and it nicely discusses both prongs of the separation of powers doctrine. As I said, I'm not going to burden you with cases today, but in this particular case, the state legislature passed a law allowing the governor to issue a stay on his own, issue a stay to prevent the withholding of nutrition from a person who was a vegetable. That passed, and the husband, if I recall correctly, wished to withdraw the feeding tube, and the Florida Supreme Court ultimately said that the state legislature had encroached on the powers of the judicial branch by authorizing the executive branch to issue a stay. Stays are issued by courts. And in addition to that, the court found there was a violation of the non-delegation doctrine, which is the part on the side there. No branch may delegate its constitutionally assigned power to another. Non-delegation doctrine, similar to the doctrine in federal law, and essentially found that the structure of the statute was so vague that it was unenforceable in a court. That is, in substance, the test for the non-delegation doctrine. If you look at it and it's unenforceable, then in other words, a court reads it and doesn't know what to do with it, then the non-delegation doctrine is violated, and the doctrine of separation of powers is violated. All right, that's a basic principle that we all just need to know. Secondly, next, then let us proceed to Article 3. Article 3 is the legislative article. The way the Constitution is set up is that you have Article 1 is the Declaration of Rights. Article 2 has various different pieces to it. Article 3 is the legislative branch. Article 4 is the executive branch. Article 5 is the judicial branch. And then we go on into specific areas after that. Whoops, going the wrong direction. There are two major concepts to understand and appreciate in Article 3. The first of them is understand the types of laws. The second is to understand and appreciate what is called the legislative single subject rule. All legislation passed by the state legislature, every law passed by the state legislature must contain only a single subject, and the title must generally describe, we'll see the language in a minute, generally describe what is in the law itself. We will start with types of laws. There are 4 types of laws in this state. There are general laws, there are special laws, there are general laws of local application, and there are appropriation acts. I have given you a definition of a general law. It is quite straightforward. But as with all of these things, it can be tricky in the application. A general law operates universally throughout the state. It does not have to be universal in application, but it has to be universal. It has to operate universally throughout the state. A hunting license comes to mind as a law that is a general law. If you want to get a hunting license, you meet whatever those requirements are, but not everybody has a hunting license. So it applies to everybody. It is universally applicable, but not everybody has one. A special law, sometimes called a local law, a special law is designed to operate upon particular persons, places, or things. In order to be constitutional, in order to pass muster under the Florida Constitution, a special law that is designed, as I said, to operate upon a particular person, say a particular county or place, city of Tallahassee, or things. There's a special law that applied to vaccination of dogs in Pinellas County that went all the way to the Supreme Court at one point. Things. Special laws, there are two significant characteristics that must be present for a special law to pass constitutional muster. Number one is found in Article 3, Section 10. Article 3, Section 10 says that no special law shall be passed unless notice to seek enactment thereof has been published in the manner provided by general law. Such notice shall not be necessary when the law, except the provision for referendum, is conditioned to become effective only upon approval by vote of the electors. So if there is a special law, you just look at these things, that applies to a particular person, place, or thing. The dogs in Pinellas County, by way of example. The city of Tallahassee. Osceola County. Whatever it is. Your antennae go up. And somebody back there smiling saying dogs are not things, right? Well, I know, but we're talking law. I agree with you. There must be notice, otherwise that law is invalid. And the other important condition of a special law is that it may not pertain to a list of things found in Article 3, Section 11. Look with me, if you will, to the Constitution. It is important, by the way. It is important. The text of the Florida Constitution is important. Always start with the text. Look for an answer in the text. This is not the United States Constitution. It is much more detailed. And so oftentimes, and the things that I will be emphasizing are frequently found in the text itself. We talked about the doctrine of separation of powers. We are now talking about types of laws. And there are two sections pertaining to special laws. And one of those two sections, Article 3, Section 11, one of those sections, Article 3, Section 11, pertains to general laws of local application as well. Let's look at them. If you look at your Constitution and go to Article 3, we will see Article 3, Section 10, which I just read to you. And following that, and I want to read some of this to us, Section 11, prohibited special laws. It should read prohibited special laws and prohibited matters relating to general laws of local application. That would be a much better signal to us. Let's read. There shall be no special law or general law of local application, a specific type of general law. We'll talk about that in a minute. Pertaining to, and then you have a whole list of about 20 or so items. And those include things that you would expect. Things that you would expect. Assessment or collection of taxes for state or county purposes. You would expect the tax laws of this state to apply statewide. Rules of evidence in any court, you would expect them to apply statewide. Punishment for crime, you would expect the criminal laws and punishment to apply statewide. Divorce, you'd expect the divorce laws to apply statewide. Legitimation or adoption of persons. Hunting and freshwater fishing, and so on. Those are things that, if you just think about them, would be accepted out of a special law. You wouldn't want a special law to cover those sorts of things, and general laws of local application. So, now that we have a definition of general laws, we have a definition of special laws, let's go to the next one, which is a general law of local application. These do, in fact, get tested. Not infrequently. Special laws and general laws of local applications and even appropriation acts. If they're not one of those, you ask yourself, is it a general law? General laws of local application. These are general laws. From where do they emanate? From where do they emanate? They emanate from the Florida Constitution. That's why we're speaking about them. And just give me a second. They emanate from the Florida Constitution, and tab 4. They emanate from Article 3, Section 11B. That's where it starts. That's where it starts. Let's look at that. Let's go back to the text, please. We've gone through the list of all the things that are prohibited, both as to general law, as to special laws and general laws of local application. So we know that a general law of local application, as just like a special law, may not pertain to the list of things that you just wouldn't want it to. Down in B, it says, in the enactment of general laws on other subjects, meaning other than the 20, political subdivisions or other governmental entities may be classified only on a basis reasonably related to the subject of the law. So we're speaking here about laws that pertain to political subdivisions of the state, counties, and school districts. Municipalities would be included here. And the first rule, or a rule, one of 3 rules, is that the general law, because it's not going to cover the whole state, it's going to cover just part of the state, similar to a special law, but they're 2 different things. Divide the question. 2 different things. They, according to just the text alone, whatever that general law is, whatever that general law of local application is, must be reasonably reasonably related to the subject of the law. These laws are known as population acts. Population acts. In order for them to be valid, there are 3 requirements. They are up on the screen. When I analyze a question on this subject, I go from bottom to top. These laws pertain to any time you see a number in a question, like at a population number in a question, 50,000 people, 100,000 people, 250,000 people, whatever it is, your antennae ought to go up. You run through the types of laws, and one of the things, if it says 50,000 counties of 50,000, we know it's not a general law. If it says it pertains to counties of 50,000, it might be a special law. But if that special law has not, if there's not been notice or referendum, one of the 2 requirements for that special law, if challenged, will be found to be unconstitutional. Another possibility for the upholding that law is that it may be upheld as a general law of local application. In order for a law to be found constitutional as a general law of local application, usually known as a population act, that's why you always watch for the numbers. The case that I cite here, the McGrath case, says, bottom to top is the easy way to do this. First, it cannot pertain to any of the 20 forbidden categories in Article 3, Section 11A. Of course, you will not be expected to remember all 20, but the concept, if you just remember the concept of Article 3, Section 11A, if you get a question that has a population number in it, you can think about whether or not it's the sort of thing that there should not be ordinarily would not expect a law that would apply to just part of the state. But if you happen to have, which you will not have, but if you happen to have the Florida Constitution in front of you at some point, you just go and look. If the law pertains to any of the 20 forbidden categories, you don't need to go further. If it does not, which most of the time it does not, then the next question is whether the population classification is open-ended or not. Open-ended means that whatever is being regulated can come and go in the regulated category. I'll give you an example here in a minute. And finally, the Population Act must be reasonably related to the population classification. There must be a reason. Rational relationship would be the test one might use. Reasonably related to the population classification. Is there a reason? Is there a reason for this particular regulation? Here's how these things come up, and here's how you would see them in a test question. A county passes, the state passes a law, okay? That law does not have a notice provision in it. And an individual is affected by that law and wants to have that law declared unconstitutional. There are all sorts of claims that might be made to have a law declared unconstitutional. One might claim that it violates due process. One might claim that it violates equal protection. One might claim it violates the right for privacy, whatever it is. We're looking at a potential challenge here. If you're the lawyer or the person wanting to challenge, and you say, okay, let's look at the type of law here. You bring a lawsuit, obviously, and you sue the state of Florida, and you allege that this is an unconstitutional law, that it is not authorized under one of the three categories here. Set aside Appropriation Acts for the moment. Once that occurs, it is the job of the state or the county, perhaps, to defend it and demonstrate that it is a constitutional, that the law passed is a constitutionally acceptable law. The government, the state or the county, will come back and it will say, the lawyer sitting in his office and then in court will say, well, you know, I'd really like this to be a general law. That's the easiest one, right? If it applies statewide and it's everybody has to get a driver's license. Let's take a driver's license. You go in and it's easy. You know, somebody's challenged, I don't need to get a driver's license, say that it's a right, not a privilege. That sort of stuff, by way of example. Setting that aside, the government lawyer might say, well, this is a general law. End of discussion. The judge probably agree. It's a general law. You've got to have a driver's license to drive in this state. But let's say that that's not so, that this law pertains to well, let me give you a real case that I teach in my class. Let's say that the state legislature at some point passes a law. We have 67 counties in this state. One point passes a law and says that for counties that have a population between 38,700 and 43,400, for counties of that population, at the time this law is passed, there can be no nudist colonies, okay? It's a real case. I didn't make this one up, okay? And so let's claim Mr. Bessinger, happens to be the plaintiff in the case, has a nudist colony in Pasco County. As it turns out, at the time that this law is passed, back in the 60s or something like that. And the sheriff goes out and arrests him for violating the law. He then is there and he challenges the law. And one of the things that he challenges is that this is an unconstitutional law. But it pertains only to one county. All right, so now we have the state attorney coming in and being required, if he wants to keep him in jail and prosecute him, to defend the constitutionality of the law. What do? The first thing that state attorney is going to do is say, is it a general law? That'll take 2 seconds. No. Next question, is it a special law? Well, it sort of looks like a special law, doesn't it? Because it only applies to one county, and that's what the definition of special law is. But then that state attorney is going to look a little further into this law when it came through the legislature, because he or she will want to know whether or not there was any notice given. Notice can be given in one of two ways. One is in a newspaper of general application. There's a statute that lays it out. It says published in a manner provided by general law. This general law still is newspaper notice. Or alternately, that law when it was passed might have had a referendum condition in it, that it only goes into effect in any county where it is applicable, under my hypothetical Pasco County, if the people vote prove it. So the state attorney looks at it and says, nope, there's no notice. Okay, so her or his, her time, you know, she's sort of getting down to the end of things. All right, it's not an appropriation act, right? We don't have to worry about that. So the last chance the state attorney has to uphold this law is to claim that it is a general law of local application. It has numbers in it, 38,500 to 43,400, whatever I said earlier. It has numbers in it, and so the state attorney quite appropriately says, well, maybe I can make this a general law of local application. And so she runs up the list. First, does this law pertaining to Pasco County pertain to any of the 20 forbidden categories in Article 11, Section 3A? If you run through it, it's not a, well, I guess it's pertaining to punishment for crime, but it doesn't, that is one place where you could stop. It appears to me now that I think about it. Punishment for crime, yeah, I think you could stop there. But I'm going to carry it all the way through, okay? I'm going to carry it all the way through. If it was not one of the prohibited laws, must not have been there when this case came through this is the 1968 Constitution, so I've confused myself. It didn't exist back when this law was passed in the 50s, early 60s, folks. So it would have passed muster under Article 3, Section 11 back in the day. Today it would have a difficulty. But what I'm trying to illustrate is you run up the tree, okay? And you go as far as you need to. The state attorney must run the table, is another way of putting this, must run the table, must prove all three of them to have this law declared a valid and therefore constitutional general law of local application. The first question would be, well, is it, as I said on the list? Well, it happens to be today, but get us back in an older time. Let's assume that it is not. The second question is this law open-ended? What did I say an open-ended law had to be? An open-ended law is a law where whatever the regulated entities are can come in and leave. Come in and leave. The reason is this is a general law, albeit of local application. And one of the hallmark of a general law is once that general law is passed, it applies on and on and on ad infinitum. That's the reasoning behind it. It helps remember things. This one is not open-ended, is it? It only applies to counties with a population category of a certain population at a particular day. There are several cases that make that point. But let's assume that it was open-ended, and we'll go to the last question, which is really what the case went off on. It didn't go off on the others. Was this law reasonably related to the population classification? Was this law restricting nudist colonies reasonably related to, was it 38,000 to 43,000 reasonably related? And the answer, according to the Florida Supreme Court back in the 50s and 60s, was no, it's not reasonably related. There's no reason to have a population, a cap or a ban for nudist colonies. If you want to have a nudist colony, have a nudist colony. And that's really what the case went off on that subject. That is how it works. Caveat. The trick question would be a question in which the number pertains not to a political subdivision of the state, but rather a branch of government. Note what I said. I read B, 11B, which said, in the enactment of general laws on other subjects, political subdivision or other governmental entities may be classified. This provision does not apply to other branches of government. And you would see it most likely over in the judicial branch. You might see something that might say, among other things, that a bill passed by the legislature that says that if foreclosure cases in a particular county particular circuit get above 50,000, then that circuit, by majority vote, can place them all in some sort of administrative resolution process. That law would have lots of problems, but it could not possibly be defended on the basis that it is a general law of local application, because general laws of local applications do not apply to the branches of government. The second point, the second piece of Article 3 that we need to know, second major point, is the legislative single subject rule. Oh, Appropriation Acts. Let me just say it quickly. You can read Article 3, Section 12, and you'll find that Appropriation Acts are sort of their own general laws, okay? And for appropriation laws, which spend the money, obviously, the legislature, they're a separate thing. They have to be passed once a year, and they can only pertain to appropriations. You can't load them with all sorts of conditions, in other words. Any condition has to directly pertain to the appropriation. But the most important thing is that, contrary to the other three acts, the other three types of laws, where the governor can veto it, but must veto the entire law, with respect to appropriations acts or appropriation laws, the governor has a line item veto, unlike the President of the United States, by the way. The governor has a line item veto, and if he doesn't like the appropriation for my courthouse, God forbid, he can, if I ruled against him or something, he can get revenge, right? Okay, happens. All right, how are we doing on time?
You were kind of right up at, you started at 3:15, it's 3:44.
So I should be finishing this?
Yes.
Oh my God. We're going to move along. Article 3, Section 6. We can do this. This will happen. I've done it before. The single subject rule, we go back to the text. Article 3, Section 6 says, every law shall embrace but one subject and matter properly connected therewith, and the subject shall be briefly expressed in the title. Now, I'm going to try to reach for the rafters here. I just need about 3 feet taller, right? Reach for the rafters. Remember this. You get lots of single subject type questions on the exam. They've been done at least twice or 3 times that I know of. That has 2 parts. It has the single subject part and it has the title part. Be sure to write something about the title part. Be sure to say something. You get points for it. No matter what you say, you get points for it. That's the whole idea of this. The single subject rule will kind of pop into your head. So, there it is. There's the rule. There's the statute. Well, what is that? What is that? On the single subject side, the act, the bottom line is really it. If you want to try to remember one sort of phrase that'll get the attention of a grader, an act of a law may be as broad as the legislature chooses, provided that the matters have a natural and logical connection, a single subject. The underlying purpose, if you want to try to remember more, are found in A, B, and C. To prevent log rolling, prevent surprise or fraud, and as to the title, fairly apprise people of the subjects of the legislation. You're supposed to be able to go to one of these laws and look at it and look down and see whether puppy dogs are, I don't know why I'm thinking about puppy dogs today. I love puppy dogs. Puppy dogs are in this law and have to be vaccinated. If they're going to do that, the title has to say it. The law may be just fine, but it has to be in the title as well. Talk about the title, all right? Where do you see this? You'll see this in both criminal and civil cases. You will see it, for example, this case that I happen to mention here is a sort of a well-known case where you have something that looks like two criminal laws, but you really have a criminal law and a civil law. One enhances punishment for crimes, and the other allows for a damage action, a statutory cause of action for damages for the violation of a stay-away order. You'd ordinarily have that anyway, you know, for stalking or assault or whatever. And you see it on the civil side oftentimes with medical malpractice and insurance, something like that. Your antennae should go up if you see something that has two different subjects in it. Okay? And not only that, it's in this little title thing in this paragraph, so your eyes, I know, are going to go through it, would for me, and you skip over that little piece saying this is an act relating to whatever it is. That is Article 3. I'm going to come back if I have time, and I'll give you a better example of it. Article 5, the judicial branch. I said with respect to Article 4 that we would wind it into Article 3. We have done that. There's nothing else in Article 4 that you folks can't just read on your own. With respect to Article 5, again, let me take you, please, back to the Florida Constitution. Where are we? Where's the here it is. Florida Constitution. Article 5. Judicial branch. Judiciary. The sections for you to be familiar with are Article 5, Sections 1 through 6. The rest of them I wouldn't worry much about. They're all about judicial qualifications, commissions, and funding and payment of judges and vacancies and how to fill them and all that sort of stuff. I wouldn't spend much of any time at all on that subject. Article 5, Section 1. Important. First sentence. First sentence. Highlight it in red. The judicial power shall be vested in a Supreme Court, district courts of appeal, circuit courts, and county courts. In the state of Florida, there can only be 4 courts. The state legislature cannot create another court if it wanted to. Couldn't create municipal courts or justice of the peace courts or whatever you might want to think of nowadays. And if it did, not only would it violate this constitutional provision, but there'd be a second thing you could write, and that is it violates the doctrine of separation of powers because the legislative branch would be encroaching on what? The judicial branch, right? See how all this comes together? That's Section 1. Section 2 has an important line, again in the first sentence. The Supreme Court shall adopt rules for the practice and procedure in all courts. It says the Supreme Court shall set the procedures, not the state legislature, not the governor of the state of Florida. It is the Supreme Court, and they are very jealous about it. They're not going to let the state legislature set up the rules for doing X, Y, or Z, however often the legislature actually tries to do it. That is important to recognize the way you see it. Sometimes in a test question is something that might say, a line that might say, well, all rules passed by the Florida Supreme Court must be approved by the state legislature. Your antennae should go up, right, just like that, okay? And probably separation of powers too. Don't ever forget about separation of powers. They set the rules not just for themselves, by the way. They set them for every court. The county court, the circuit court. They set my rules, whether I like it or not. And they set their own rules, which we all have to like, right? Okay. And it goes on. Anyway, that's the way it is. Number 3 through 6 establishes the jurisdiction of those 4 courts. Section 3 is the jurisdiction of the Supreme Court. It is actually quite expressly stated. Okay, we're not quite there yet. It is pretty well stated there. As you go through, the next one is the District Courts of Appeal. It is there's a fair amount of substance to it, but it's not quite as detailed as the Supreme Court. Then we have circuit courts, which are less detailed, and basically they're the court of general jurisdiction in the state, and they have all the power that is not by statute given to the county courts. Let's see here, how do I want to do this? We are going to start. I knew I was going to do this. I just figured I had to say it. That's all. We're going to start at the top and work down. We're going to learn the jurisdiction of each of those 4 courts, starting with the Florida Supreme Court. I will say at the outset that the Florida Supreme Court is a court of limited jurisdiction. Its jurisdiction is set forth smack in Article 5, Section 3 that we are going to run through and summarize. The legislature is not able to give the Florida Supreme Court any jurisdiction that is not listed therein. It's a violation of the express text of the Constitution and a separation of powers issue. The other important factor to remember with respect to the Florida Supreme Court is that it is a supervisory court. One of its main functions, in addition to setting forth the procedures that are followed in all of the courts, which of course is supervisory over primarily the district courts of appeal, the next level down, because we have in this state 5 district courts of appeal, and sometimes one court will rule one way, one court will rule another way, and part of their job, as we will see, is to resolve those conflicts. The next level down, the district courts of appeal, are known as error-correcting courts. You get one appeal in this state, and it's not all that hard. If you have a final order or a non-final order of a certain type, you get to come talk to people like me for $300. Pretty good deal, isn't it? You only get 10 minutes if I give it to you, okay? You better have a good story. That's what they do. So I had a guy lately comes in, he says, "Well, Your Honor, that's my story." I said, thank you, sir." He sat down. I thought that was nice. Good old gentleman, about 90 years old. He was. So, let's go to the top and work down. But let's begin by picking up this Extraordinary Writs piece, please, by Judge Northcutt. Since we're starting with appellate jurisdiction, we need to know, am I doing any better? We need to know when you get on top and look down and make the divide here, what is the divide in the types of jurisdiction that the appellate courts have? The appellate courts for this purpose are the Florida Supreme Court, the District Courts of Appeal, and a unit of the Circuit Court called the Circuit Court Appellate Division. We're going to find out what all three of those do. And the world of appellate jurisdiction is divided in two. First, there are appeals. And as you can read on page 1 of the Northcutt piece here in more detail, appeals are mandatory for the appellate court. By filing a notice, the appellant compels the court to entertain the appeal. If it's an appeal, the court must consider it. For $300, I've got to look at it, whether I want to or not. Appeals arise from the case below. They are appeals of whatever the final result are in a criminal case or a civil case or a family case or a probate case, or certain non-final appeals that by statute and by constitutional provision and rule can be appealed. So they are appeals from plenary appeals. There are plenary appeals and appeals from a very limited set of non-final orders. And what is the purpose of an appeal? If you have an appeal, you get to come talk to whatever that appellate court may be. It may be, if it's a county court final judgment, as we will see, that appeal comes up to the Circuit Court Appellate Division. It goes up the chain. It gets much tougher as you go up. It's mighty hard to get to the Florida Supreme Court. But it goes up the chain. And it's mandatory review. What do appellate courts look at things? If it's an appeal, they look for two basic things. One is, was there an error of law? That's what appellate courts do. We don't care what, as long as there's some factual support in the record. We don't worry much about the facts. And the other major issue raised is whether or not the trial judge abused her or his discretion in making some ruling. Evidence coming in, evidence not coming in. Criminal case. Criminal cases are carefully watched for what evidence goes in. You ordinarily don't put in evidence of past crimes, with some very limited exceptions. And that's an abuse of discretion call by the trial judge. That's what an appeal is for. Original proceedings, what are they? They're issued in an appellate court's discretion. They originate in the appellate court. Most importantly, they are collateral to the main case, collateral to the merits of the case. In all of the 6, except for certiorari. Certiorari in a limited case allows you to rule something that's going on. We will get to original proceedings. We will learn momentarily what those original proceedings are. They are writs of certiorari and extraordinary writs. As I said, appeals, and the Northcutt piece here on page 1 lays it out very nicely. Hopefully you all got sort of a copied or highlighted piece there. And appeals are mandatory. They're for direct rule of what's happened already. And their purpose of the review is set forth on this slide. Original proceedings are different. They're discretionary. They're collateral to what's going on in the main proceeding. Maybe it's a recusal of a trial judge. Maybe it's a violation of a speedy trial provision, something of that line. And they are, with the exception of certiorari, injunctive in nature. And I'll explain what that means momentarily. I will do original writs after I go through the jurisdiction of the 4 courts. So let us begin. Much of this starts out from the Constitution itself, so you might want to have Article 5, Section 3B3. Thanks. Article 5, Section 3B3 next to you, just so you at least know where it is. Because it is a supervisory court, and now I'm summarizing for you Article 5, Section 3B. That's the jurisdiction of the Supreme Court. There in all of its glory for us. And because it's a supervisory court, the mandatory jurisdiction of the court is very limited. And it is precisely and expressly stated in the Florida Constitution, the mandatory jurisdiction, meaning that the court must hear the case, set forth on the left-hand side of the slide there. The Florida Supreme Court must hear appeals in death penalty cases, just by virtue of a defendant filing a notice of appeal. The Florida Supreme Court must hear appeals from a district court of appeal order or opinion, decision they call it. It's got to be written down by the district court of appeal. You can't just make it up. Invalidating a constitutional provision or a state statute. That's what that says. In the details of things, death penalty cases skip over the district courts of appeal, thank God. And you file a notice of appeal in the circuit court, and it goes directly to the Florida Supreme Court. The constitutional, the next one down, invalidation of constitutional provisions, emanates out of the district court of appeal and only out of the district courts of appeal. And the reason for that, if you think about it, is that if a district court of appeal declares a statute unconstitutional, notice I emphasized, then we are doing something that is arguably disrespectful, if you will, to the state legislature. And they don't like that. And so that's the humor. The real point is that it's a serious matter when one branch of government tells the other branch of government you don't know what you're doing, right? And so the serious point is if it's if it's an order, if it is a decision, something has to be in writing, finding it's unconstitutional, then find it a statute or constitutional provision. That's what's going on in all these gay marriage cases around the state. Then that goes up to the Supreme Court after it gets through the district courts of appeal. The next one, and then I'm not going to bother with the last one. The next one, bond validation proceedings. I mentioned that because we're going to spend times on tax and finance when we get to bonds. Those I hate to equate them to death penalty cases. They're nothing like a death penalty case. But the reason bond validation proceedings also go directly from the circuit court to the Florida Supreme Court simply by filing a notice of appeal, and it is an appeal. And the reason for that is that when state and local governments are borrowing, the markets are changing daily, and you don't want to wait around for some slow district court of appeal judge who get off the golf course, right? Okay. I don't do that. You would never, right? Not Monday through Friday. Never. I don't want that television station after me. Okay. So there you have the mandatory jurisdictions. Florida Supreme Court, by constitutional provision, has lots of discretionary, has discretionary jurisdiction in certain precise categories. What are they? As I already suggested, I just put the main ones up here. That if there is conflict between one district court of appeal, there are 5, 62 people like me, or 3, something like that. It's hard to. How do you think they ever got 61 other people like me, Judge Dean Singer? That's pretty arrogant, I know, but you know, we have to have a second of moment to breathe. if there's conflict, the Florida Supreme Court, in its discretion, doesn't have to. It's like the United States Supreme Court. You know, they didn't take the gay marriage cases right away. They waited until there was conflict, right? If you're following that. And so you have actually two types of conflict here in Florida. You have express and direct conflict, where the lawyers will argue that it is, or sometimes a district court of appeal will certify something that what I'm saying is the judge of the district court of appeal conflicts with what somebody else said on the first district court of appeal. But even then, it is discretionary. Other ones that are worth remembering are pass-through jurisdiction, okay? I'm jumping around here. Pass-through jurisdiction is found in, that's just a short name, Article 5, Section 3B, 5. May review, court, this is discretionary, the Supreme Court may review any order or judgment of a trial court certified by a district court of appeal in which it is pending to be of great public importance or to have a great effect on the proper administration of justice throughout the state, and certified to require immediate resolution by the Florida Supreme Court. An election case. If you all remember the 2000 election, the George W. Bush first election, those things started in the circuit court in Tallahassee for the most part. We had a few down here in Miami. And once they came out of the circuit court, there was no district court of appeal that touched them because we needed a president. So they just sent them up to the Florida Supreme Court. Florida Supreme Court ruled, and the U.S. Supreme Court then thereafter came along. Election case is a pretty good example of that, and so on. Somebody tried, one court, the second, tried to certify the gay marriage cases, but those were deemed by the Florida Supreme Court actually not to be, what did I say? Require immediate resolution by the Supreme Court. So it's a very narrow sort of thing. Sir?
Just real quick on the mandatory and the discretionary jurisdiction between cases for mandatory jurisdiction for the Florida Supreme Court cases invalidating law or construe a provision from the district court, and then over on the discretionary cases construing a provision or state federal constitution. Is one expressly stating, the DCA is stating that the law or the constitutional provision is invalid, or the state law is invalid, or what's that line between?
Which one are you talking about? Which number?
Supreme Court, right? So mandatory and discretionary.
Correct.
Both down from the second one down from the top. So the case is invalidating a constitutional provision.
I see what you're saying.
Right? And then what's the other one? Like, they're just basically saying like.
Fair point. Fair point. By the way, if you have any questions, I'm not as bad as I say I am. You can raise your hands. So, he's right. Mr. Varka took my class, okay? But he's not afraid of me. He interned for me too, and he was afraid of me. He's right. The point here is, I have this fancy thing. Should I try to use it? No. Don't worry about it. I saw, what am I supposed to do with this?
You're supposed to clip it.
Some here? Is Megan Kelly coming to interview me? Is that why I have this? You know, I figure there has to be some reason for all this stuff. That's all right, don't worry about that. For Christmas.
You got a laser pointer?
No. My Christmas present. I'm trying to find it. My daughter will be very upset. I got a pointer and I got one of these things that I now cannot find. Here it is, right here.
There you go.
How do you do this? Press a button?
Don't look in your eye. Don't look
Yeah,
in your
probably.
eye.
Yeah.
That's what my ophthalmologist does.
I don't think he uses a razor.
Yeah, that
Probably does.
It should go there, but it doesn't.
Might need a battery.
It might. It's on.
Just turned on a second ago.
Joe, press the thumb button.
Yeah,
The little
oh,
gray button.
there we go.
I do have a pointer in the car.
A stick?
Yeah, would it be embarrassing if I ever brought my pointer here?
There's a little button back here.
Judge, there's one on the side. There you go.
Ah, that's how it works. The wonders,
Yahtzee.
Yahtzee,
Yeah.
the wonders. What Mr. Bark is trying to create trouble here is he's right. We have, okay, let's be serious. Mandatory jurisdiction, death penalty cases, bond validation proceedings that we're going to talk about more because of the reason I said, markets. Because of the branches of government, laws, decisions, written decisions of the District Court of Appeal invalidating a constitutional provision, which has never happened by a District Court of Appeal, by the way, yet. Might someday. Or a state statute. That happens all the time. What Mr. Varka is asking us about correctly is, okay, this is where you have the decisions about cases invalidating a statute. That's really what we're talking about here, statutes. And that can go directly. Somebody has to file a notice of appeal, by the way. The Florida Supreme Court's not going to be able to look at it if somebody doesn't file a notice of appeal. But what he's correctly pointed out is if a District Court of Appeal, bless you, finds a statute constitutional, then the Florida Supreme Court, as a matter of discretion, can still review it if a petition for review is filed. The Supreme Court cannot review anything unless somebody asks them to. And next, of course, cases construing a provision of a state statute, same sort of thing. Then we get down here, express and direct conflict, certified direct conflict, pass-through I've talked about. Coming back up a couple, we have decisions expressly affecting a class of state or constitutional officers, something that might affect, say, all state attorneys in the state, and questions of great public importance. And of course, we can have any court of appeal in the United States can certify a question to the Florida Supreme Court, and the Florida Supreme Court will usually look at it as a matter of comedy. That gives you an idea of what they are. Original jurisdiction, as I said, I'm going to wait to the end. Advisory opinions, the only one, the Citizens Initiative is part of that packet that I said you could review on your own. That's Article 4, Section 10. The one I will mention, though, I think that's probably worth talking a mention, Article 4, Section 1C. The other two, don't worry about. Article 4, Section 1C, going back to Article 4, I don't mean to be jumping around. But there is a provision of Article 4, Section 1C that permits the governor to request in writing the opinion of the Justice of the Supreme Court as to the interpretation of any portion of this Constitution upon any question affecting his powers. It's very limited, but it exists. The things to remember are probably, well, mandatory jurisdiction, all three of them there, and have a pretty good grasp of discretionary jurisdiction. We'll come back to original jurisdiction and so on. The District Courts of Appeal, as I said, are the error-correcting courts. Their jurisdiction is constitutionally provided by Article 5, Section 4 of the Florida Constitution. It just kind of reads right along. And summarized, being the error-correcting court, Article 5, Section 4B1 provides constitutional authority to the District Courts of Appeal to review for legal error or abuse of discretion all final orders issued by any circuit court in its geographical area, whether it be criminal, civil, probate, family, you name it. The district courts of appeal also have mandatory jurisdiction over certain non-final orders. That proceeds constitutionally from Article 5, Section 4, B1, stating that the district courts of appeal, may review interlocutory orders in such cases to the extent provided by rules adopted by the Florida Supreme Court. Now, I don't know how all that happened, but what you have there are some selections where the Florida Supreme Court, by rule, because that's what this says, has given the district courts of appeal jurisdiction upon filing of a notice of appeal, because the district courts, like the Florida Supreme Court, don't have jurisdiction unless somebody files a notice of appeal. And those are areas where you might expect there to be a need for intermediate review before the end of the case. Whether or not case should have been ordered to arbitration is a pretty good example of it. You know, you just can't wait to the end, because if an order is entered denying a motion to compel arbitration, the defendant really has, if it goes all the way to the end and then wins, really doesn't get much vindication. Another one that is pretty easy is the right to immediate monetary relief or child custody in family matters. Divorces can go on, and child custody, you can't just wait to the tail end to find out where the kid should live in the meanwhile. Sometimes if one party to the dissolution has more than the other, you need a court order telling whoever has the money to even up the score. A few others: immediate possession of property, because we value property rights. Personal jurisdiction would be another one, sort of like arbitration. You can't wait to the end very easily, otherwise the defendant, you know, if all he gets is dismissal, if that's what he's entitled to, he really has not had much of a remedy, and so on. Again, talking solely about mandatory jurisdiction, there are certain administrative orders that by law, authorized by Article 5, Section 4B2, allow a direct appeal of administrative action to the district courts of appeal. The provision says that district courts of appeal shall have the power of direct review of administrative action as prescribed by general law. The Florida legislature has given all of the district courts of appeal direct review from the agency action, skips over the circuit court, directly to the district courts of appeal of final orders under the Florida Administrative Procedure Act. That's the main one. A few others is there. And then as we see, district courts of appeal have mandatory jurisdiction. And I'll come back to cert later. Before I go to the next slide, what I want to point out is that, look, remember, okay, I'll go back up here, except I don't want to get too much exercise. The Florida Supreme Court has no certiorari jurisdiction. Remember that. Remember that. Don't forget it. It's like me hanging from the rafters. The district courts of appeal and the next level down, circuit courts do have certiorari jurisdiction. Only 2 of the 3. It was taken away from the Florida Supreme Court because they were misusing it. They were bad folks. They were. Somebody got them, so to speak. Not like that, but anyway. So, there's the jurisdiction of the district courts of appeal. It has appellate jurisdiction and has original writ jurisdiction. Let us move to the next level down. We now get to the trial courts. All of this with respect to the trial courts, by the way, I have attached the appropriate sections of the state statutes, and you can go through and read them and kind of double back, and maybe it'll be a little easier for you to try to put enough of this in your head, so to speak. Circuit courts, the statutes are listed up there. The circuit court is the main court, is the court of general jurisdiction. As I said, a unit of every circuit court in the state. There are 20 circuit courts in the state, by the way. Every county has a county court. By definition, a county court. There's 67 counties, so we have 67 county courts. Some counties up north have only one county court judge. Down here in Dade County, we have 30 or 40, something like that. So, the circuit courts by statute, 26.012, or actually by constitutional provision, excuse me, constitutional provision, the circuit court shall have original jurisdiction not vested in the county courts, and jurisdiction of appeals when provided by general law. They shall have the power to issue writs of mandamus, quo warranto, certiorari, prohibition, and habeas corpus. Those are the original writs. That's what all this says. And that's what these statutes flesh out. The jurisdiction of this general well, let me actually do it the opposite way. The county courts, the circuit courts are going to have jurisdiction, as I just read, of anything not provided to the county courts. The county courts, by statute, have a limited amount of jurisdiction, although they're super busy. They have, in the civil side of things, they have jurisdiction over actions at law. That's complaints, damages, actions that do not exceed $15,000. They have jurisdiction over violations of municipal and county ordinances. They're all the statutes, all the authorities there. Homeowners association disputes, as I say, nobody wants those. Landlord-tenant disputes below $15,000, and limited and injunctive relief, again down below $15,000. The county courts also have criminal and quasi-criminal jurisdiction. The criminal jurisdiction is probably the only one you need to remember, probably, although it doesn't take much to remember. Traffic violations are non-criminal, we know that. Misdemeanors are misdemeanor, the jurisdiction, county courts have jurisdiction over what I wrote there, misdemeanors not cognizable in circuit court. What do I mean by that? Everything has an exception in the law, sadly. If a misdemeanor, if you go out and commit a crime, okay, let's say you break into somebody's car, the cops come, you get arrested for breaking into the car, and then you sass the cop. Sass the cop, could well be resisting arrest without violence. That's what it's called. That's a misdemeanor. Well, those have to be combined because otherwise the smart defense lawyer is going to go down to the misdemeanor court, plead the guy guilty, and then come out and say, okay, he's guilty. He was found guilty, and double jeopardy, prevents the trial of the car break-in or the murder or whatever else was involved. So it can be pretty serious. Everything that is not in the jurisdiction of the county courts is over in the real, the ones that really carry the heavy load, the circuit courts. And in the civil side, I've taken out of the statutes things you'd expect, cases over $15,000, family I mentioned, probate I mentioned, guardianships, juvenile cases, crimes committed by kids under 18, landlord-tenant above $15,000, and so on. All felonies are in the circuit court. We have a big felony court here in Dade County and elsewhere around the state, and that is also circuit court. Bond validation proceedings, remember I mentioned something about it already. It starts in the circuit court, skips over the district courts of appeal because that needs to be decided quickly, up to the Supreme Court, and then of course there's equitable relief. So that's the first piece of the text. Text is important for our purpose, as you can now start to see, versus as against the U.S. Constitution. And the other piece of it, just rereading the sentence: circuit courts shall have original jurisdiction not vested in the county courts, and jurisdiction of appeals when provided by general law. By general law, which is, I think it's 26.01, and probably some of the others. The appellate jurisdiction, it's like a pyramid, okay? You've got the county courts way down, you got the county courts down here. For any final orders of the county courts, with some exceptions, minor exceptions, the appeal, or if it's an original writ situation, I talked about the divide, on either side, the ordinary and usual next step up is to the next place up. So the county court, if you're representing somebody in the county court and you are the defendant and you have a $10,000 verdict entered against your client and you want to appeal, you go to the circuit court. Similarly, you will see, I've kind of extended it out here more than necessary, you will see that the circuit courts have the same types of original jurisdiction as does the district courts of appeal. That's more detail than we need here, but they have all 6 of them: prohibition, mandamus, quo warranto, habeas, certiorari, and all writs. We'll talk about that momentarily. And so if something happens in the county court, let's say you believe that your judge is biased, you would file a petition for writ of prohibition. Where would you go? This collateral writ, next level up into the circuit court. Okay. That's how that works. So there we have general jurisdiction. I think we've covered the jurisdiction of the courts. How am I doing?
Maybe about 10 minutes.
10 minutes, all right. All right, then, let's see, what am I going to do then? We can do this. Let's talk about writs, okay? Writs are sort of less tested, not too much on writs. I can use this to catch up. Here's how this works, okay? Writs. Take this home. Read it tonight before you go to bed. It's my order. This is easy. Okay, you got 20 pages or so here. The first, page 2, gave you the divide, right? There are 6 original writs. Turn over to page 9. Skip certiorari, the odd one. Turn over to page 9 with me, and you will see 1, 2, 3, 4, 5 of the 6. Prohibition, mandamus, habeas corpus, quo warranto, and all writs. If you look at those, you get a pretty good description of what each of them is used for. If you go back a little further, from page 9 to page 11, you see the definition of prohibition, which you see already on page 9, repeated at the top of page 11. And you'll see the elements of prohibition if you really want to kind of get into it a little further. And then after that, you'll get examples of the most important ones, the most used purposes. Most used purposes, and it looks to me like the copies have them highlighted just like mine are highlighted. So prohibition, you see, is used to prohibit a judge from taking jurisdiction over a person after this speedy trial time has expired. These are mandatory, these are injunctive, these things are injunctive in nature. Prohibition prohibits a trial judge from continuing with a case if the speedy trial time is run. Prohibits a judge from exercising jurisdiction over the case if he or she should be recused. That sort of thing. Mandamus, as it sounds, commanding the trial judge to do something. Commanding a lazy trial judge, usually I just have so many things on their desk, but from commanding a trial judge to rule on a motion. Things get lost sometimes. And so on. And then the last, just running through quickly, is, habeas. We know what habeas is. Commanding the government to explain why this person is being held in custody. It's an order, a command. All writs is not all writs. All writs is used to maintain jurisdiction of the courts. In a family law case, the all writs is used. Here's an example. In a family law case, the boat is parked out here. Husband and wife are in a divorce proceeding, and the key's in the boat, and the husband's on the way to the boat. That's when you get a court order, all writs to maintain the jurisdiction of the court over the boat, that sort of thing. Certiorari, a little bit, or no little bit? Little bit. Certiorari is a little bit. Look at the chart. There's first and second certiorari. You get one appeal in this state. That's all you get from a final order. One appeal. After that, it is certiorari. Certiorari exists. Two exists. First tier certiorari exists to review quasi-judicial administrative orders. A mouthful. Quasi-judicial administrative orders. Not otherwise reviewable by the Florida Supreme Court. There's only one, I didn't even mention it, Public Service Commission administrative orders, or not otherwise reviewable by the District Courts of Appeal. Those are left in what I'll usually call the basket. And the first tier certiorari means it goes to the first court of general jurisdiction, which means the circuit court. It's over on the discretionary side of things, back where we already talked. Oops. Right there. It's an original proceeding. The other piece for certiorari is second tier certiorari. As I said, you only get one appeal. And so, if you're in the county court and you have an adverse verdict, your plaintiff defendant, whatever it may be, or criminal defendant, and you lose, you can appeal to the circuit court. If the circuit court appellate division affirms the conviction or affirms the money judgment, you can try to go higher. It gets tougher each step of the way, but it is by certiorari again. It is discretionary as to whether or not the courts do it. Doubling back, there is no certiorari jurisdiction. I will stand on the rafters here. I think I did already, didn't I? Something like that. There is no certiorari jurisdiction in the Florida Supreme Court. Don't let them trick you, because they do. They try. All right, what's next? What's next? It's time for a break or not?
You have a rule section on local government.
Oh, you want me to do local government? Yeah, we can do that. That won't take us long. Then we'll take a break. Okay, this is good. We're doing okay. All right. The reason we go to Article 8 next, okay, there's a reason to the madness of the organization of this. You know, I left Article 1 to the end because it'll be somewhat familiar to you. The reason I now go from, we now have a base sort of thing that you can see how questions will be developed on the bar exam around jurisdiction, around the courts. Not unusual sort of thing. And we've talked about single subject rule could get thrown in the question, or general or types of laws could get thrown in the question, or whatever else we've already talked about. This piece is here because it sets the stage for Article 7, the tough part of this, the toughest article, I think. This and Homestead, the toughest two articles or sections of the Florida Constitution. The point here is to appreciate the difference for after the break between what are constitutional political subdivisions of the state and what are not constitutional political subdivisions of the state. And the reason I bring that up at this point is that oddly, we will learn here soon that a constitutional political subdivision of the state, counties almost always here in Florida, have the ability to levy an ad valorem tax on certain properties owned by municipalities or special districts. You would not think that one entity of the government could tax another. Well, life is not easy. And we will learn that counties can tax under certain circumstances property owned by a municipality and special district. So there you have the hierarchy. I put a line up there. The state, of course, is at the top. It is sovereign. Counties and school districts, which are constitutional political subdivisions, by which I mean they are constitutional political subdivisions required by Article 8, Section 1. The state, by the state constitution, says the state shall be divided by law into political subdivisions called counties. So they have the same degree of sovereignty, or close thereto, of the state. They're constitutional required entities. School districts are the same. If you look at Article 9, Section 4 of the Florida Constitution, you will see that every school district, that every county is required to have a school district. A couple little ones can combine if they want to. Every county is required to have a school district. So that's the reason that I put that there. The other piece about Article 8 is a corollary to what I just said. Sections 1 and 2, again, point up the difference between counties and municipalities. Counties are political subdivisions of the state. Municipalities may be established or their charters amended or abolished by general law of the state legislature or special law of the state legislature. With respect to counties, we have 67 counties. Of those 67, 65 of them are either charter counties or non-charter counties. You need to know the difference between charter counties and non-charter counties. You do not need to worry about, in my humble opinion, worry about the fact that Miami-Dade County happens to have its own constitutionally established form of metropolitan government. Those of you who live in Dade County know that. I believe you'll be fine if you just know the difference between charter counties and non-charter counties. Duval County, for those of you who've ever been up there, lived up there, is a constitutionally based, consolidated county. Something a little different than a metropolitan Dade County. And those are the only two that have either come around to doing things a little bit differently than the other 65, and I don't think I'd worry about it. What you do need to know is the difference between a charter county and a non-charter county. A charter county has a charter. That charter is approved by the state legislature. A non-charter county has no charter. What are the difference? There are actually more non-charter counties than charter counties in this state. What's the difference? The difference is set forth in Article 8, Section 1, F and G. Simply stated, oh, it's in here. My goodness. Okay, here's the kind of the bullet point way of looking at this. Non-charter counties may enact any ordinance, back up. May not enact any ordinance that is inconsistent with either general law or special law. We covered what a general law is and a special law, right? The second thing that restrains the powers of non-charter counties is that a non-charter county, a municipal ordinance in a non-charter county trumps any county ordinance with which it conflicts. Everybody follow me? Okay. So a county cannot, I mean, we have counties, all counties have some municipalities and have some unincorporated areas that are not, not incorporated, not incorporated. With respect to non-charter counties, they may not pass any ordinance that is in conflict, or they may not constitutionally pass any ordinance that is inconsistent with special and general law, and whatever ordinances are passed by any municipality within that county trump any county ordinance in conflict. Charter counties have greater authority. This, by the way, has been a single question on the exam, difference between charter counties and non-charter counties in the past.
Essay question?
Yes, it was a single essay question. Either you knew what a charter county was or you didn't know what a charter county was. End of discussion. Charter counties, bullet points. A charter county may not enact any ordinance that is inconsistent with general law. And with respect to special laws passed by the state legislature that affect a charter county, consider my puppy dog vaccination law, Pinellas County, that special law is effective only if approved by the electors of that county. So a charter county, by definition, right, has more leeway and authority than a non-charter county on that score. In addition, the other major difference, the other bullet point, is that in charter counties, the county, the Board of Commissioners of the county gets to make the choice as to which one will prevail in the event a charter or a county ordinance conflicts with a municipal ordinance. And the county commissions have gone different ways. You would think that a county commission would always say that in the event that you would think that a county commission of a charter county would always say that our ordinances prevail in the event of a conflict with a municipal ordinance. They can, but they haven't always done so. So those are the bullet points, the 2 bullet points for each. Know them. How are we doing?
Well,
Pardon?
we're kind of over you're probably half hour behind.
Half an hour? Oh my God. Can we take a short break? Having established the base points about types of government that we have the state. Can anybody get rid of that?
In the bottom right-hand corner, click on the little slideshow.
Bottom right?
Where the percentages, bottom.
Dean Singer will do it for me. We have established the base. We know that counties and school districts are superior in status to municipalities and special districts. We now move to how state and local governments raise revenue, how they fund themselves. They do it in 3 ways. They tax them. They do it through taxation. Second way they do it is in non-tax revenue-raising methods, off-text, off-TEXT methodologies. And finally, through borrowing. Borrowing in the government world is bonds. It's like a mortgage on your house. With respect to tax and finance, Article 7 is the controlling article, obviously. And again, we divide the question. With respect to taxation, Taxation is covered in Article 7, Sections 1 through 9 of the Florida Constitution. Borrowing, bonds, is covered in Sections 10 through 18 of the Florida Constitution. We are going to work through both, and we are also going to talk about non-tax revenue-raising methods that are listed there, remembering that they are off-text, off-text, but exist and are important and are tested. The beginning of wisdom here is to appreciate, let me get my notes out because it'll go a little better. Just give me a minute, this will work a little better if I do it. 3, I want 2. Here we are. This is the one. The beginning of the wisdom is to discuss Article 7, Sections 1 and 9 and see how they fit together hand in glove. Remember, I just said that Article 7, Sections 1 and 9 are the taxation side of the Florida Constitution, the taxation revenue-raising methods, the limits on revenue raising. 10 through 18 is borrowing. Let's read them together, please. Read them with me. First, no tax shall be levied except in pursuance of law. Sounds simple, but the most important sentence in Article 7. Thus, the Florida Constitution expressly prohibits the state or any subdivision thereof, that's what this sentence is all about, from exacting a penny from any of its citizens. I'm talking taxation now, unless pursuant to law. A law has to be in existence. What is law? Law, there are 2 types of laws. There's the organic laws of this state, constitutional laws, and there are statutory laws. Those are the 2 types of laws. So, in order to determine what the authority is for state and local governments to tax, we look first to the Constitution. We start at the top. That takes us over to Article 7, Section 9. Fits together. Article 7, Section 9 says in 9A, county school districts and municipalities shall, and special districts may, be authorized by law to levy ad valorem taxes, and may be authorized by general law, that's important, to levy other taxes for their respective purposes, except that ad valorem taxes on intangible personal property and taxes prohibited by this Constitution. Taxes on intangible personal property fall over to the state side. The state can levy an ad valorem tax on intangible personal property. The state cannot levy an ad valorem tax on real estate or personal property. You have to read those carefully and understand them totally, folks. That's the only way to do it. Read and understand them. So, we know, therefore, we started out by saying no tax shall be levied in pursuance of law. We look at the Constitution, and we see that county school districts and municipalities and special districts are authorized by the Florida Constitution to levy ad valorem taxes and any other taxes that the state legislature by general law allows them to do. Then we go, that's point A. Point B, as I said, is that with respect to ad valorem taxes, there are all sorts of taxes. Ad valorem tax is a tax on the value of property, whatever that property may be. It might be real estate, real property. It might be tangible personal property, these desks. It might be intangible personal property, usually promissory notes. Promissory notes executed in connection with putting a mortgage on your house. You pay an ad valorem tax. You pay an intangible tax based upon the value of that promissory note to the state of Florida. So, there's the constitutional authority right there. And then the remainder of it, the remainder of the tax has to be authorized by law. The only law, and the only way that it can be authorized is by general law. There's a famous case, Alachua County versus Adams, which is on another slide, that so states. And so the idea is to make, the way it works out is that local governments are financed primarily by ad valorem taxations. The state of Florida has a very limited ad valorem taxation base, intangible personal property, which would include, as I said, promissory notes and stocks and bonds if they chose to tax the value of them. But ad valorem is always on the value of whatever that piece of property is. Okay, so just backing up, there's something, let me summarize that point. This you may want to write down. Drawing together just these two provisions of the Florida Constitution, we therefore know, I'll go a little bit more slowly, that except for the express constitutional authority given by the Florida Constitution to counties, school districts, and municipalities to levy ad valorem taxes on real property and tangible personal property, parenthesis, remember, dash, intangible personal property is accepted, that's what's an EX, accepted, close parenthesis. These local political subdivisions of the state and all other political subdivisions of the state, including by way of example special districts and water management districts, must have general law legislative authorization to levy a tax. Does everybody have that? Who wants it? Does everybody have it?
Must have one.
I don't think we have it.
Do you want it again?
Yes, please.
All right, here we go. Drawing together these two provisions of the Constitution. This is base stuff, okay? We know that except for the express constitutional authority given by the Florida Constitution to counties, school districts, and municipalities to levy ad valorem taxes on real property. Everybody so far so good? Yeah. And tangible personal property. Same provision. Parenthesis, remember, dash, intangible personal property is accepted, E-X-C-E-P-T-E-D, close parenthesis. These local political subdivisions of the state, referring back to counties, school districts, and municipalities. These local subdivisions of the state and all other political subdivisions of the state, including by way of example special districts and water management districts, must have general law legislative authorization to tax, period. That summarizes Article 7, Section 1 and Article 7, Section 9, right together. Okay. Finally, to the extent that ad valorem taxes, which is just one type of tax on the value of property, whether it be real estate, tangible personal property, or intangible personal property, are levied. It can be levied no matter who owns it against that individual, whoever owns that real property or personal property, so on. And the ad valorem tax, the tax is based upon a set amount per dollar in mils. A mil is 1/10 of 1%. I just say that so if you see something like a mill, we're not talking about a flour mill. And finally, and very importantly, with respect to ad valorem taxes, as distinguished from all other types of taxes, which might include sales taxes, gasoline taxes, cigarette taxes, excise taxes, or corporate income taxes, all of which belong to the state. With respect to ad valorem taxes, Article 7, Section 2 says all ad valorem taxes shall be at a uniform rate within each taxing district, except the taxes on intangible personal property may be at different rates but shall never exceed 2 mils on the dollar. What that means is that with respect to ad valorem taxes, which are levied by local governments, they're levied by Miami-Dade County, they're levied by the city of Miami Gardens, they're levied by the South Florida Water Management District, they're levied by special districts, of which I have a definition, by the way, on one of these slides. They all have to be uniform within that district. If Miami-Dade County levies an ad valorem tax, the school district is an ad valorem tax. It's one of those listed right up on the prior slide. That ad valorem tax, 6 mils, whatever it is, has to apply to every piece of property in Dade County, unless exempt. Churches are exempt, things like that. So, that's all of that. What's next here? So there you have how the first level of taxation, going back to our list, okay? 1A, taxation of individuals and how it's done, the divide between what the state can do and what local governments do. Local governments can only levy other taxes if authorized by general law. A supplemental sales tax, half penny, for example. The second thing, as I mentioned before the break, is that because counties and special districts are inferior in status, they are not sovereign entities. And accordingly, the property owned, real property, almost always is what's involved, could be tangible personal property. Counties can levy an ad valorem tax on the value of property owned property owned by a municipality or a special district. Sounds weird, but there has been a total question on the bar exam on this very subject. Well, that ability, it is summarized right here, by the way, my divide that I've been talking about. States, counties, and school districts are immune from taxation. As I said, other government entities may be subject to an ad valorem tax. Those include municipalities and special districts. But there is a partial exemption for property owned by municipalities and special districts. The exemption, as the municipality exemption, is expressly stated in Article 7, Section 3, the next section down, and is carried forward by case law to special districts. A special district, I've defined down here, is like the South Florida Water Management District. Manages all the water for 8 or 10 counties in the state. You might have a special district to take care of certain pieces of land or something like that in a municipality. Using the exemption for municipalities, not all of their property is taxable by ad valorem taxes. I'm talking ad valorem taxes, folks. It is taxable except that all property owned by that municipality and used exclusively by it for public purposes is exempt from ad valorem taxation. How does this, and the same concept applies to special districts, just a different type of governmental entity. How does this work? Consider Isla Mirada. Down there, and let's assume there's a little island there, and on that island, we have three things. The island is owned by the city of Isla Mirada, which is a city down there. We have Monroe County as the county. On that island, hypothetically, we have a city hall, we have a Chili's restaurant, and we have a marina. Monroe County sends a letter to the city of Isla Mirada and says, we are hereby levying an ad valorem tax on the value of your entire island. City of Isla Mirada says, not so fast. Part of that island is my city hall, is our city hall. Look at Article 7, Section 3. All property owned by a municipality and used exclusively by it for public purposes. That city hall falls smack into the definition. Let's talk next about the Chili's. Is the Chili's exempt? The property under the Chili's I'm talking about, because that's what's owned by the city of Isla Mirada. The property itself belongs to the Chili's company. All property owned by a municipality. Well, it is owned by a municipality. Is that property where the Chili's sits being used exclusively by it for public purposes? No. So, Monroe County can levy an ad valorem tax at a uniform rate. Remember, I said it has to be a uniform rate for whatever county purpose it is, the county operational tax. And so can the school district, by the way. Levy an ad valorem tax on the property underneath the Chili's. The marina is the tough one. The marina I'm positing is available for use by the people of the citizens of Isla Mirada and anybody else who wants to take their boat in there, and you can go in there and you can buy some snacks and get gasoline for your boat and store your boat or whatever. The question then is the land where this marina is, that maybe even produces a profit for the city of Isla Mirada? We go back to our little definition. All property owned by a municipality, that marina is owned by the municipality, and used exclusively by it for a public purpose. Well, arguably it's a public purpose. Is it used exclusively for public purpose? That's up to the writer of the exam. All right? That's how that works. And it works exactly the same way for special districts. Just substitute special district for municipality. I mean, think Cape Canaveral or something like that, or Cape, whatever it is up there that is not federal property. So, summarizing quickly then. This chart does it for us. Article 7, Section 1, no tax may be levied except in pursuance of law, meaning constitutional law or general statutory law. We know that local governments can levy an ad valorem tax. That's your Section 1 and Section 9. And they may, local governments, all of them, meaning municipalities and special districts here, may be authorized to levy other taxes pursuant to general law only, like a sales tax surcharge. And there are lots, so what that all means is the major source of revenue for local governments, ad valorem taxes, whereas the state, because it has a plenary power to tax, has all sorts of ways it can tax you. Sales taxes, gasoline taxes, excise taxes, intangible personal property taxes, corporate taxes, and they do. So, local governments are therefore cash starved, right? So what do? What have they done in the last 50 years? They have created what I call non-text, off-text, T-E-X-T methods of revenue raising. You need to know the tests, T-E-S-T-S, for each of these. These are fees. These are not taxes. Impact fees, special assessments, and user fees. Impact fees are one-time charges only for the impact that is being imposed on a particular development or house that is being built. Special assessments are recurring charges. User fees are what it sounds like. The tests are set forth on the slide. What is an impact fee? An impact fee, if you're a developer, and are going to build 100 houses, that the development is going to have an impact on the roads, the sewer systems, the schools, anything else you can name. What local governments do nowadays, and I'm speaking here of counties and municipalities, what they do is they charge an impact, and that impact is based upon evidence to determine what it is going to cost for the additional school child, or what it's going to cost for the additional roads. And out of the 100 houses, it gets divided by 100, very, very roughly speaking. And the developer, if he wants his permit, or the company wants his permit, it's going to pay those impacts. So out of any $100,000 house, $25,000, I'll guarantee, is going to be impact fees. You just don't know it when you buy the house. And they're just that, okay? They're for the impact that is caused. Well, what's the rule? What's the rule on that subject? In order for that type of charge or exaction to be a valid fee and not a tax, the government, if challenged, has to prove that the two prongs. One, that a reasonable connection or rational nexus exists between the need for the additional capital facilities, the road, etc., and the growth of a population generated by the subdivision. And two, that a reasonable connection or rational nexus exists between the expenditures of funds and the benefits accruing. The latter is secured by the requirement that the money, the fee, be put in a separate bank account and used for the road, the school, the sewer system, whatever it may be. How does this arise? It arises as follows. I buy a house. I spend $100,000 for the house. I'm just doing it all by myself. And I go out to get the permit, and the city of Miami Gardens says, fine, I'll give you your permit, but you're going to add $500 to our sewer system, $500 to our schools, $500 to our roads. I'm going to charge you a fee for that, $500. I'll say, no, that's not a fee, that's a tax. And it is an unconstitutional tax because it is not authorized by general law. The state legislature has not said that I can exact that money from you. There's no legislative authority. It's not in the Constitution, obviously, because it's only in Article 1, Section 9, right? Then that doesn't allow it. And it's not an ad valorem tax. So my challenge, my complaint says that it is an unauthorized tax, because all taxes must be levied in pursuance of law. That's how you see these cases. That's how you see them on the exam. And it then turns back, once that allegation is made, it is the government's obligation to demonstrate that it is a valid impact fee. And they have to demonstrate that at the time they calculated that fee of $500 for the road or $500 for the sewer system, that there is a nexus between the need for the capital facilities, the road, and the growth. Yeah, I'm going to cause $500 additional road needs, say it. If they can show that they did that, then I lose. It is not a tax, it is a fee charged to me for causing an additional impact in the county. And then that $500 has to go, as I said, into a separate bank account, and it must be used to facilitate my area, the roads in my area. It can't be used in Homestead, it has to be used up here in Miami Gardens. Special assessments, variation on the theme, but a significant variation on the theme. Unlike one-time charges, special assessments are recurring charges. Think fire suppression services, okay, fire trucks. The city of Miami Gardens, if it needed a fire service, has to have it, all the time. They might, rather than using their ad valorem tax revenue, because there are limits on that ad valorem tax revenue. If you look at Article 7, Section 9B, there's a 10 mil limit on it. They might say, all right, I'm going to have a special assessment for the fire suppression services. And the way we're going to do this is everybody in Miami Gardens is going to pay annually, recurring, is going to be assessed annually an amount that relates to the amount necessary to maintain and have those trucks and the people ready to go out. In order for that, again, all right, I live here, I file a complaint, I say, and that's an unauthorized tax because that assessment is not authorized by any law of the state, any general law of the state legislature. Government, Miami Gardens, has to come back and meet the two-pronged test. The services at issue provide a special benefit to the property, certainly do, provide a special benefit to my house here in Miami Gardens, and the assessment is being levied as that the assessment is properly apportioned. My house pays less than a commercial building over there on 199. Okay? And if the government can prove that, then the special assessment lives. User fees are exactly what it sounds like. You spend $300 to come and see me, or $500 to incorporate a corporation, and it has to be reasonable. We go next to bonds. We have looked at. This is important because you see cases alone on bonds. We've gone through Roman numerals 1 and 2. What are bonds? There are 3 types of bonds. Bonds are found, the bond, remember, Articles 1 through 9 is tax, 10 through 18 is borrowing. Let's go to 10 through 18, go to the text, and you will see, beginning with Section 10. Section 10. Says, neither the state nor the county, school district, municipality, or special district or any agency shall give, lend, or use its taxing power or credit to aid any corporation, but this shall not prohibit laws authorizing. I'm going to drop down to C and tell you at the moment, without going in detail, that is the industrial bonds provision, economic development bonds provision. The borrowing, the provisions, the main one, let me see. State and local governments. The ability of state and local governments, all of them, to borrow is limited by the state constitution. the legislators can't go out in a given year and just borrow to the hilt and make it all come, leave it to somebody else. That's what this is all about. And there are limitations on all levels of government, as I said, and they're set forth in this chart. To the right-hand side here, you have state bonds. That state bonds ought to be up a level. I just couldn't type it, not me at all, but we just couldn't get it up there. State bonds, those are the three columns on the right. They're general obligation bonds, revenue bonds, and dedicated state revenue bonds. Over on the left, you have local bonds, and in the middle you have what I just mentioned, economic development bonds. Let's run through them, okay? We can go to the text. State bonds are governed by the limitations on borrowing by the state of Florida are set forth in Article 7, Section 11. Article 7, Section 12 is our limitations on local government borrowing, and then industrial revenue bonds are back where I limit on that are back there where I just said. State bonds. Article 7, Sections 11A through C, the first three sections, tell us that if the state of Florida is going to borrow money and pledge its general revenue, meaning the full faith and credit of the state of Florida, to repay those bonds, the Florida Constitution limits it. There have been questions solely on bonds, folks, so listen. I know it's late, but listen. The state of Florida is limited in its ability to borrow. And it is limited, it may issue those bonds only to finance the cost of state fixed capital outlay projects, number one. And only upon the approval of the electors of the state of Florida, the voters. Meaning that the state cannot borrow for operational expenses. It can borrow only for fixed capital outlay projects, state university buildings, state capitol buildings, state roads, state-run sewer systems, whatever else there might be of that type. But because the public fisc is at risk, that's the way I present it. The public fisc is at risk. Remember that. It's a nice little ditty, I guess we might call it, whatever it is. Call it what you want. If the public fisc is at risk, then there must be a vote, okay? However, column 2, if the public fisc is not at risk, meaning that the state of Florida is borrowing bonds and those bonds are going to be paid back by something other than the state revenues, then there's no requirement for a vote. Example, the Skyway Bridge over there in St. Petersburg goes back and forth over there. That is built with a state bonds borrowing, and it is the only source of repayment that whoever owns those bonds can look to are the tolls for that bridge. If there are not enough tolls, they don't get to sue anybody else. State of Florida is not up there and valid for it. There are some exceptions to what I just said, both for general obligation bonds and revenue bonds. The revenue bonds are the ones where the revenue is coming from elsewhere, but I'm going to let that to you. Local bonds are the state analog. Local bonds are the state analog to general obligation bonds, okay? It's the same thing, same philosophy. Same philosophy as for state general obligation bonds. Local governments, Dade County, City of Miami Gardens, special districts can borrow money. But if the public fisc is at risk, meaning for local governments, the ad valorem tax base, that's what funds local governments, we've learned, right? If the public fisc is at risk, then 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 the money that is borrowed may be used only to finance capital outlay projects, and there must be voter approval. Again, the notion is to be sure that the Board of County Commissioners or City Commission doesn't go out there and just borrow like the devil in order to make themselves look good and let somebody else pay the consequences down the road. If the public fisc is not at risk, if the public fisc, let's see here, how are we going to do this? If the public fisc is not at risk, if the public fisc is not at risk for local government borrowing, okay, if the ad valorem taxes are not pledged for repayment of the borrowing, then there's no need for a vote. It still may be used only for the public purpose, but no need for a vote. Okay. And if the public, if the ad valorem taxes are sort of as a guarantee back in the back, but they're not really at risk, then we get into this business of what is a public purpose and a paramount public purpose. If the public fisc is at risk, there must be a paramount public purpose. Otherwise, there just needs to be a public purpose. And I left you a slide on that. The last one that is really important, because this gets tested on its own several times. Industrial revenue bonds. These are economic development bonds. These are bonds issued to bring companies into the state. The key thing, I tell you, the key thing when you get a bond question is to look to see, number one, is it a public project that is being financed in the hypothetical, or is it a private project that is being financed through a bond issue? If it is a public project, then you're off in either state bonds or local bonds. If it is a private project, meaning, which by definition means an economic development project, since the state is not allowed to just lend its credit to anybody, that if it's a private project, then it must meet the industrial revenue bond test. That is found in Article 10, Section C, Article 10, Section C, right, Article 7, Section 10C. I've outlined it for you. Industrial revenue bonds may be used to build airport and port facilities or industrial and manufacturing facilities when the bonds are payable from the project and the interest is tax exempt. So that, for example, if there is a Publix distribution facility being built in North Florida, and the state of Florida wants to incent them to do it in Florida rather than Georgia, what happens is the state, the local government up there, local government, because this only applies to local governments as well. Local governments borrow the money, they give it to the Publix corporation. One of the conditions is that the bonds are payable from the project, and by virtue of this constitutional provision and law that's developed around it, the bonds must be tax exempt, and you get that letter from the federal government. But it goes even beyond that to other capital projects. The provision might appear to be applicable only to capital projects. It can, and the law has said it can be to other capital projects, providing that that the project serves a public purpose or paramount public purpose, as I said, and as defined in my handouts, and meets those requirements. Okay. All right. We now go to homestead, everybody's favorite subject, right? Article 10, Section 4 is homestead. This Article 10, Section 4, there it is in all its glory. And it is intended to protect the family home, family farm, whatever it may be. And Article 10, Section 4, for historical reasons, imposes 4 types of limitations on property that qualifies as homestead property. We'll show you the test in a minute. First, it provides, Article 10, Section 4 provides an exemption for the life of the homesteader, the person that owns the homestead. Provides a lifetime exemption for the homesteader from creditors' claims of that, the owner of the homestead. It provides a death time exemption to a spouse or heirs. That does not mean that the homestead continues, it is just that the benefit continues. I shall explain. That's 4B. It additionally provides a restriction on the devise of property owned, a restriction, a limitation on the devise of homestead property, and a restriction on alienation. Here's the provision, okay? These provisions are mostly separate. A is the one that provides for the lifetime exemption, lifetime benefit. Lifetime exemption. A, it reads, there shall be exempt from forced sale, except for the payment of taxes, assessments thereon, obligations contracted for the purchase, improvement, or repair thereof, or obligations contracted for house, field, or other labor performed on the realty, the following property owned by a natural person. 1, a homestead with certain size limitations, and 2, personal property to the value of $1,000. What does that mean? We have to ask ourselves first, this is for the person, this is the person who owns the property, and the property is homestead. We're going to get to that in a second. So what type of property can qualify? As I just read, it applies only to real estate, because it says a homestead if located outside of a municipality to the extent of 160 acres and so on, and personal property to the value of $1,000. So the type of property that can qualify for homestead protection is either real property or personal property up to a value of $1,000. Now we come to the question is, how do we know that that property, whether it be real property or and personal property, is it homestead or not? Here's what we do. We look at this piece of property. We ask ourselves first, is this property owned by a natural person? If it is owned by a corporation, a business partnership, an LLC, or whatever else you can think of, it is not protected homestead. But in addition to that, the property must meet the size and contiguity requirements of Article 10, Section 4A1. So we have to go back and look at that. Assuming the property is owned by a natural person, then going back to the provision itself, if that piece of property is located outside of a municipality, then the homestead, the protection of homestead can extend up to 160 acres outside a municipality. If it is located inside a municipality, then the protection is limited to 1/2 acre. And it also says that if it's located outside of a municipality, then that 160 acres does not lose its exemption just because it is subsequently annexed. So we have this division here, subdivision, outside a municipality, inside a municipality. A homestead located outside a municipality to the extent of 160 acres and contiguous land thereon, contiguous land and improvements thereon, which shall not be reduced without the owner's consent by reason of inclusion by annexation in a municipality. But if located within a municipality, then to the extent of 1/2 acre of contiguous land, but notice the qualifications, comma, upon which the exemption shall be limited to the residence of the owner or the owner's family. Think with me. What that means is that if the property is a 1/2 acre in Miami Gardens, and if the owner of that property meets the qualifications, nevertheless, by virtue of that last phrase, if the Miami Gardens person here who owns 1/2 acre has his house on the front 1/4 acre and on the back 1/4 acre has an orchid farm, say, the creditor can come and take and execute upon the business because it's not his or her residence. That's important to know. All of this goes to protection from creditors' claims. The natural person is living in that house, and the whole idea is to protect that person while he or she has owned the house. We're at the 4A stage. On the other hand, go back up 2 sentences, 160 acres, there is no such limitation, is there? And not only that, if it's annexed, it doesn't matter. So, can the owner of that 160 acres, the farmer, say, who has 160 acres out here just west of Miami Lakes, can he or she, or it has to be a person, natural person, can he build a Marriott on that property? No. The answer is yes.
It won't be homestead.
Yes, it will be homestead. Really? Yes. The laws of homestead may or may not make sense, folks. The whole idea is to read and apply them. That's all you have to do. I mean, there's a whole history behind it that I don't have time to get into. But the thing is, read, read, read. But of course, that farmer still has to be living there. But he's out here in Miami Lakes and he doesn't need cows anymore. He can have a Marriott and do better. Okay? So, If the property is homestead, damn it. If the property is homestead, then it's protected from creditors' claims while that person is alive. That ownership need not be in fee simple. It can be a life estate, by way of example. And going back up to my rafters point here, the homestead character of that property terminates, I'm up at the top here, terminates, everybody's going to remember this when the question comes up on the exam, that I'm holding the rafters and pulling it down, right? It terminates when that owner dies, when the owner of that property, when that natural person dies. Why is that? Why is that? Help us remember. That is so because the property has to be owned by a natural person, right? And there's no longer any natural person. That person's gone. They're not so natural when you're dead, so I'm told. So, the homestead character of that property ends, and we'd be all over. We'd be ready to go get a glass of wine, except that since 1838, there's been this 4B provision that says, 4B provision that says that the exemptions that decedent had inures to, just those exemptions, everybody with me, hopefully? Those exemptions inure to a surviving spouse or heir as defined in section 731.102 of the Florida statutes, the laws of intestate succession. The protections that the decedent had, okay, I die, my wife outlives me, I had $50,000 of credit card debt. That MasterCard company cannot come and collect on my property because my wife is there. The whole idea is to protect the family. And if I die intestate or devise the property to an heir as defined by the statute, it's the same thing. Even if my heir is my second cousin, as long as it fits in that list. Because the idea is to protect the family. This is just something you learn. It may not make sense. My cousin may be Donald Trump, I wish, okay? But he gets the protection of my little house. I don't wish, really. But, so that's the inuring clause. Remember, just running back quickly to 4A, when the person's alive, there are some exemptions. Obviously, if I own my house and I'm not paying my mortgage, my taxes, my assessments, or if I hire a contractor to come in and build an addition on my house, all of those things are exempted out. That's what that bold piece in 4A is all about. What else? Okay, we know it terminates when I die. Of course, it terminates if I sell. I mean, it terminates rather if I abandon. If I own my house and I decide to go get a house in Coral Gables or something, then this house, and I own two places now. The homestead character ends on my Miami Gardens place. If I sell it, obviously it ends, and so on. All right, the inuring clause I've already covered. Who is an heir? An heir is person under the intestate succession statute 731.201, and the creditors still cannot. My creditors cannot execute on my heir's property or my spouse's property. However, that does not apply to the heirs of the person acquiring the property. Tricky. I die. The heir happens to be my cousin. Okay? My cousin lives in Pennsylvania. he now has title by virtue of the laws of intestate succession, assume. His Mercedes creditor can come on down and execute on the property he has down here. Because what inures to the benefit of my cousin up in Pennsylvania is only the protections that I had. Think. It's hard. I mean, it's just the way it is. Okay? What my cousin can do is he can quickly get on down here and make that his homestead the moment I die. Get on down here before the creditor, before his Mercedes judgment creditor comes down and puts that judgment on the property. Then he gets the benefit of the protections that I, as the decedent, give him, my MasterCard people, and at the same time, he gets, because he is now the homesteader, he qualifies under the statute, he gets the protections as well. Lastly, oh my God, no, we're not going to do that. That's really a great chart. Lastly, or almost lastly, there is a prohibition for the same reasons. For the same reasons, C. Okay, these things are kind of separate, as I said. Where is it? Come on. Come on. I don't know who did all that silly stuff. Must have been somebody with some time. C. Quite apart from what I just said about the inuring clause, there's a but if. The but if is that my homestead property cannot be devised by me to somebody else if I'm survived by either a spouse or a minor child. There's a prohibition on that. Why is that? We go all the way back to the whole purpose of this thing, to protect the family. So, if I have a minor child in particular, but either one, it says the homestead shall not be subject to devise. So if I give my homestead to Mr. Varka in a will, and I happen to be survived by a spouse or a minor child, which would be the case now, you wouldn't think, would you? I'm old. But that's a whole other story. We don't have time for that. We got to get a glass of wine. Minor child, what happens? The devise fails, right? It says not subject to devise. Okay, if it's not subject to devise, what is it? You go to the laws of intestacy. We don't have a will. Oh my goodness. No, you don't go to constructive trust. It doesn't get that. It's not that complicated. You go look at section 40. Here it is. This is wonderful stuff. You know, would somebody call my assistant and tell her not to do that ever again? If not devised, okay? If I have a minor child, which I do. If not devised, is authorized by law and the Constitution. Because it's not. It's invalid. The homestead shall descend in the same manner as any other intestate property. I just said that. But if the decedent is survived by a spouse and one or more descendants, that's my minor child, the surviving spouse shall take a life estate, God bless her, in the homestead, with a vested remainder to the descendants in being at the time of the decedent's death per stirpes. You all know that because you took wills and trusts. What that means is it's not just my minor child, but every other child I've had in my life. God knows how many there were. You still awake? And, however, most importantly, the bane of my existence back there, if my spouse is smart, which she is, smarter than me, she will elect to take an undivided half interest, and then she doesn't have to worry about all my kids because they, however many there are, because they get the other half, and that's it, and they can divide it up by however many there, God forbid, might be out there. This is being recorded, right? Can we turn this off yet? Hey, listen, I've done worse. And finally, you arrived at a good time. Finally, we're going to stop this. Oh, we didn't do Article 1. This is easy. Finally, there's if alienation. If your spouse, if I own my property and I want to sell a piece of homestead, my wife has to sign. Gives her some control over me, doesn't she? She's got it anyway. Doesn't matter. Article 1. Sorry, folks, I didn't get it. Look at Article 1. I've laid out there. There'll be a lot of intuitive stuff there. I'm sorry I didn't get to it. But I laid out the ones you really need to know. All right? Go forth. Thank you. And slay a few dragons.
Okay, hang on 2 seconds. I know you're all really eager to go downstairs and get some food, but we really want to thank Judge Shepherd for his time and for his expertise, number one. Number two, we do have a very nice barbecue. Peter Kelly has put together a very nice barbecue for you, so please thank him in advance. Number three, remember we're going to do the drawing downstairs for one more raffle, and then next week we're meeting on Wednesday to do wills and trusts and evidence and something else. We can't. Some of you have a commercial class in the afternoon on Friday. That's why it's scheduled on Wednesday. So do remember again, Wednesday next week at 3 o'clock. All right. Thank you all. That's all for now.
Where's my vegetarian?